They have become members of a organization that exists for the purpose of committing crimes. Hello again. I'm Lana Manitta with Rossen Law Firm, and I'm here to talk to you today about federal racketeering, or RICO. Before we get started, remember to like and comment on this video and subscribe to our channel to see educational videos covering all sorts of criminal defense related topics. So what is racketeering? Congress has passed a statute, 18 U.S.C. 1962, if you're interested in looking it up, which prohibits a pattern of racketeering activity. The prior statute, 1961, defines racketeering activity as being any one of about 100 different offenses. I haven't counted them, but committing these enumerated offenses for financial gain. Now you're thinking, I'm sure, what's the difference between just committing the criminal offense and racketeering then? Well, it lies in the phrase pattern of activity. So what's important to know about pattern of activity under federal law is that pattern doesn't really have its normal meaning. You may be thinking that a pattern is something that repeats, usually over and over. Well, under federal law, a pattern of racketeering activity is two or more of the enumerated offenses committed within 10 years of each other. Does that sound like a pattern under the normal definition? Of course not. So the racketeering, or RICO statute, which aims to go after criminal enterprises who are making crime a business, right? Or making crime an income generating exercise, charges people who commit crimes on behalf of or because they are a part of a group that commonly engages in these certain types of criminal behavior that are enumerated in that statute that I talked about. The group usually will expect that its members will commit one or more of these racketeering acts. And this statute and prosecution under this statute subjects these individuals to this additional distinct charge. It's separate from the underlying offense. So in other words, you can be charged with the actual racketeering act, say it's extortion, and you can be charged with the racketeering as well if there is a pattern of activity. Again, two or more within 10 years of each other, which is, pattern only under racketeering law. And so the individual who's charged with racketeering is facing now, only on that statute alone, up to 20 years or even up to life, depending on the criminal offense that's underlying the racketeering charge. And that is far more under federal law than they might face just under a charge for the substantive offense, for instance, in state court. And you know that if you've been watching some of our other videos, that conspiracy is a common charging instrument in federal court. And RICO cases can sort of be thought of almost as conspiracy on steroids. RICO cases are also charged against multiple defendants, but this time they're not simply in a conspiracy, they are charged as being members of a criminal enterprise. So in other words, they haven't just agreed with one another to commit a crime or help commit a crime. They have become members of a organization that exists for the purpose of committing crimes and making money from committing crimes. And they don't really have to make a lot of money. It just has to be some sort of economic enterprise, which I can go into what the definition of economic enterprise in another video is, but suffice to say, again, it is not your standard definition of economic enterprise. So this law, this RICO law, was originally passed to go after organized crime and to put pressure on small players to cooperate against the higher ups by exposing them to these vastly higher punishments than they had previously faced, being charged in state court, for example, with assault or robbery or extortion. Now, today, it's used not only to go after organized crime, but street gangs or co-conspirators who commit a series or pattern of 2 racketeering acts who may not really be members of an organization per se. So because racketeering acts include violent offenses, property offenses, drug offenses, sex trafficking, the expansion of RICO to what would otherwise have been charged as just a regular conspiracy is not only easier than it probably should be or was originally intended to be, but is really helpful to the government in bringing the kind of pressure to bear on defendants that gets them to cooperate against other defendants. When a financial fraud conspiracy, for example, is charged as racketeering, the defendants are going to be significantly more concerned and scared about the sentence they might receive, and rightly so, and they're going to be more inclined to make a deal with the government. But defense counsel needs to be making sure that the RICO charge fits the alleged facts and that we aren't simply dealing with an example of the overcharging that I have discussed in other videos. Not every conspiracy is a criminal enterprise, so not every conspiracy can or should be charged as racketeering. If the alleged facts do not fit the charge of RICO, this is a point to be raised in pretrial motions, at trial, or in negotiation of a plea to a different offense, depending on the specific circumstances involved and the client's wishes. If I had to make a prediction, which is, not always wise, I would nevertheless predict that RICO is going to continue to be stretched to its boundaries, and hopefully the courts will set a narrow boundary beyond which the prosecution will not be allowed to go. But these boundaries are only going to be set by the courts if arguments are made by zealous and experienced and active defense counsel. If defense counsel simply accepts that it's okay to expand RICO beyond its intended use to every single criminal conspiracy, then the prosecution's going to get away with it, and that will become precedent, and that will become the law of the land. And so, it takes a long time for wrongs like that to be righted because so few cases in federal court are litigated to the fullest because of the enormous pressure that's put on defendants to plead guilty. We're already seeing this expansion of RICO from highly sophisticated organized crime syndicates of the 70s and 80s to now street gangs, which are often fairly unsophisticated, made up of teenagers or young adults who barely have 2 nickels to rub together, but are nonetheless committing, 2 of the enumerated offenses on behalf of their gang. So, being charged with a conspiracy is often shocking enough to a federal defendant. RICO charges are going to come as an even bigger and scarier surprise, and it's going to be really important to ensure that if you find yourself charged in this way, you're hiring counsel who is familiar with all of the intricacies of the complex RICO statutes, because often the defenses lie in the absence of one of the many elements that can be easily missed or misunderstood by inexperienced counsel. Rossen Law Firm has experience in federal RICO cases involving financial crimes as well as violent offenses, and has the familiarity necessary to turn over every single stone to defend against RICO charges and guide our clients to the best possible outcome in a very difficult and scary situation. So for today, that's all I'm going to be talking about with respect to RICO, but there is so much more that I could talk about in additional videos. Remember to like and comment. Let us know what else you'd like to hear about. Subscribe to our channel. And as always, thank you for watching.